morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting legal stories and live trials in the country today. Now, as you know, we've been covering the Claude Tex McIver case out of Atlanta, Georgia. We've been covering it every single second of it. But unfortunately, they are off this week. That's right. Trial is not on this week. They're taking a break. The trial will resume on Monday, April 9th. But there's so much to talk about this case. Again, it's about a prominent local attorney from Atlanta who is charged with the murder of his wife, Diane McIver. Now, authorities are saying that he intentionally shot his wife from the backseat of a moving car. But his team is saying it was all a tragic accident, that the gun misfired. He didn't mean to do this. We are going to get really into the details of this case because there was some real big developments Friday and some exciting testimony Friday. So we're going to talk about that. And we are also going to recap this entire case for you. Since we do not have the live trial today, we have an opportunity to replay the entire case for you. And really, you can understand everything from beginning to where we are right now. But before we do that, I have to talk about another case that we're going to be covering here on Law and Crime. It is a case out of Ohio, and it's a really, really sad one. It's the case of William Knight. William Knight is on trial for shooting and killing an unarmed man after going to his house to seemingly recover a dirt bike that he believes was stolen from his son-in-law. That's right. An altercation ensued, and Knight shot this man, and he is claiming self-defense. We have a short preview of this case. We believe it will start Wednesday. So here, take a quick look at this case later on this week.
The trial for the Streetsboro, Ohio man accused of shooting and killing an unarmed man in a dispute over a stolen dirt bike is set to begin next week. 64-year-old William Knight is charged with murder and assault stemming from an altercation with 24-year-old victim Keith Johnson. The dispute was over a dirt bike reportedly stolen in 2016 from Knight's son-in-law's garage. The victim had the pilfered bike in his possession and was attempting to sell it on Facebook, according to authorities. Knight and his family arranged a meeting with Johnson to discuss the sale of the bike when everything went terribly wrong. Knight alleges the victim tried to run over his daughter Michelle with the dirt bike when confronted with the stolen property.
Ma'am, they tried to kill my daughter.
Okay, hold on. Did you just shoot the man?
I had to. He was trying to.
Okay.
He tried to run into my daughter.
Okay, hold on. Okay.
Johnson's family contends the bike was not stolen and that he purchased it from another seller. Is this a case of self-defense or cold-blooded murder? I'm Rachel Stockman for Law and Crime.
Another tragic but unbelievable case that we'll be covering here on Law and Crime. So again, we believe that will start Wednesday. All right, let's get into really the Tex McIver case, okay? So we have a full day to talk all about this case, but I know you don't want to just hear from me. You probably get a little bored. So let me bring in my guest for this morning, criminal defense attorney.
We're going to probably forget much of what they've heard over the past couple of weeks, number one. And number two, you could inspire jurors to start looking stuff up that they are not supposed to do. They're going to be admonished not to do that.
How do you monitor that?
You really can't until somebody screws up and posts something on Facebook. Oh, I looked this up, But we are curious creatures, whether you're in a jury box or not in the jury box, and it's going to give them a lot of time to reflect and do things they shouldn't be doing as jurors in an active case.
Well, I should tell any juror on the Tex McIver case, don't watch us. You should not be watching this right now, so I hope they're not. But let's get into a little bit more of the details of this case. We've had some pretty exciting couple of weeks here. Yeah. I'm curious, there was an issue that we talked about in the before we came on today that I want to talk about with you. The jury may have an opportunity to handle the weapon, the .38 caliber Smith & Wesson, right, in the jury deliberation room, as opposed to actually in the jury box in front of the attorneys and the judge. Having that weapon when they go to deliberations seems problematic. What do you think?
Oh, it seems prejudicial is what it seems, and here's why. If the state were able to prove that, or knew and could present these facts to the juror, that the gun was a double action, a single action. In other words, how the state of the gun at the time that it went off. If they knew that definitively and they wanted the jurors to try the trigger to know exactly what was going through Tex McIver's mind when he pulled, did it take 12 pounds of pressure or only 2 pounds of pressure? Then it makes sense. But thus far, the prosecution is not able to say whether it was single action, double action, was his finger, how many pounds of pressure was it going to take. So when you put that gun in the hands of the jurors, you give them an opportunity to make an inference that might not exist because we don't know. And I think the prosecution or their witnesses have said it's impossible to know how many pounds of pressure it took at the time.
But listening to this, it sounds like it could work counter to both of the sides, both the prosecution and the defense, right? So if they're playing around with a gun and they say, oh, wait a minute, it's pretty easy to pull this trigger. It seems like it could be an accident. Why is the prosecution so bent on getting the jury to handle that gun?
I think they're trying to float the theory that it took it took a lot of pressure in order to pull that trigger. Ergo, it could not have been accidentally pulled in the backseat of the car when they hit a bump or the ride got rough, which is what the defense is really going to try to float. That his finger must have been on the trigger. Look, Jesse, triggers don't go off without your finger on it, usually. So his finger could have been on the trigger, but it still could have been an accident. Mm-hmm. And that's what the defense theory is going to be.
Well, we talk about the prosecution theory, we talk about the defense theory. The best way to explain it to you is from the mouths of the attorneys themselves. So we have a very lucky day today. We are going over the entire Tex McIver case. Let's start from the beginning with the prosecution's opening statements. Take a look.
Mr. Adam Abadi and Ms. Siri Lamjarou, it is an honor to represent Diane McIver, the citizens of Fulton County, and the state of Georgia in the prosecution of this case. The defendant in this case is charged with 7 counts in the indictment. Counts 1 through 4 encompass the murder of Diane McIver. And counts 5 through 7 are about the influencing of witnesses to cover up what he did to her. Diane had told Ann Schwall, the mother of Austin, that she was going to leave the ranch to her godson. And Diane loved Austin so much, she would never draft a will without Austin being included in it. And the evidence will show, we will have Mr. Carlton Morse, an expert in real estate, testify that unless Diane McIver foreclosed on the ranch and took control of it, she couldn't leave the ranch to Austin. The evidence will show that Diane could take control of the ranch by foreclosing on it if the defendant did not pay. The defendant did have a pension, and our expert would testify that based upon his spending habits, it would be depleted in 2 years after he retired. And in addition to that, without the money from Diane that he was receiving every month, on the time of her death, the defendant wouldn't even have $1.
Welcome back, everybody. So we are recapping the entire Tex McIver case because we're off this week. Well, they're off this week, I should say. Trial will resume next Monday. But before we actually get there, we have to recap where are we in this case. And the best place to start is with the prosecution's opening arguments. Now, that was the very beginning of it, so let's dissect what you've heard so far and what the jurors heard so far. Again, I'm here with criminal defense attorney Jonna Spilbor. Okay, so we're starting to hear this financial motive. But before we get into the financial motive, the idea that Diane McIver is a shrewd businesswoman, she's very tough. Yep. We keep hearing that throughout the case.
Yep.
They keep each witness brought forward by the state, that's a question they keep hitting him with. What kind of woman was she? She was shrewd. Was she mean? Did she have a sharp tongue? What are they getting at here?
The prosecution is trying to prove squarely that there was a financial motive, because we need a reason, right? We need a reason why a 70-something-year-old prominent attorney with no criminal history would want to murder, intentionally kill his wife in a car with a third person driving. We need to figure out why he would want to do that. Prosecution's theory is he was financially motivated because he wasn't worth all that much. She was worth $12 million, and his financial worth kept decreasing over the last few years. Jesse, that is a weak motive, and here's why. Number one, they were married. It's not like Diane was dealing with somebody at arm's length and was loaning all this money and stood to lose a lot if that person never paid it back. They were together. Their estate is a marital estate. It probably would have been a lot easier for him to divorce her than shoot her through the backseat of a vehicle, number one. So if that's all they have for motive, and I believe that to be the case, it really falls flat. They lived together. Tex McIver wasn't destitute. He might have not had as much money independently as his wife did, but again, this is a marital pie we're talking about.
But let me ask you this then, okay? If she really was taking care of all the vacations and she was taking care of the ranch, and we know that he was reimbursing her for that, but she was really taking care of their lifestyle,
right,
why would he need a loan?
I guarantee you, I mean, we won't find this out during the trial. My theory is the loan was to help Diane on her taxes. When you make a lot of money, you need a lot of write-offs. You need to have your business show that it's got money that it's loaned out, that hasn't come back. So you save a couple of bucks and don't have to pay it to Uncle Sam. I guarantee you that's the loan, and that's why he wasn't paying it back.
The interesting part about their relationship is that they met and came together and got married at a later point in life.
Yes.
He was an attorney, she was a prominent businesswoman. It's not like they started off, hey, we're kids, high school lovers. They grew up together. When two people come together and they have their own careers, and they, I see a little bit of a more understanding about, I'm going to loan you this money. It's a little bit of more formalities because she had her own thing going on, and then she got together with Tex. So I kind of see a little bit of a different, I think people have to step back and see that this is a different relationship than people might be used to. So if that's the case, because I know we look at our message boards, I talk to different guests, they find it strange that there would be a loan lent out between Tex and Diane. And she was making fun of him at one point in certain emails about the fact that he was really concerned about going into debt. And she said, you're going to be getting a handout like Javier, who manages the ranch, you know? So I think there's, what do you make of that dynamic?
I don't think it's going to be the motive for murder that a jury is going to have to believe in order for them to convict Tex McIver. But I do think, look, when you're in a relationship, this was a second marriage or maybe even more for both of them. They had stuff when they met each other. And surprisingly, I haven't heard any testimony about a prenuptial agreement, which would limit what Tex might have gotten had they divorced. Because if that existed, that might help the jury decide whether he was financially motivated, but I haven't heard anything about that yet. When you're married and one person holds the purse strings, so to speak, right? You have a spouse who's the moneyed spouse, and you have a spouse who doesn't make as much, right? Called the unmoneyed spouse. I can see where there might be some ribbing, especially in this day and age. Look, she had more money than him.
Yes, she did.
So she's going to rib him about it. She's going to tease him about it. But she was also helping him with these so-called loans. It wasn't like they lived together. It wasn't as if he was going to be living in a box suddenly if she decided to call get that loan back, right? She secured it by a piece of their joint property.
So do you think it matters when you heard in the opening statements, he only paid on the interest, he never paid the principal?
Doesn't matter to me.
Wasn't that their agreement? That was their understanding that he'd pay on that.
I'm assuming that it was, and I'm curious to see if we're going to have a financial expert on behalf of the defense come in and talk about the things I'm talking to you about. Was this really a loan on paper to help Diane and her businesses, which is common? I'm not saying that that was a bad thing. I'm saying that's commonly done. But the prosecution is making it look like without that $350,000, he wasn't going to eat tomorrow. That was not the case.
Let me just circle back to the question at the beginning. The idea that they keep painting her as a difficult person to be around. We know that she teased him, things about his weight. We know that she had a sharp tongue. Is that, okay, if we can't get him on the motive that it was a financial gain, she was really breaking his back on a lot of stuff. That's a reason for murder? I think, do you think the prosecution is really trying to say he killed her because she wasn't nice to him?
They are really reaching. So what they're probably doing is throwing up as many possible theories and let the jury fetter it out. You know, anybody on that jury who's ever been in a long-term relationship, whether it's a marriage or something else, knows that it's not all roses and sunshine and unicorns and rainbows all the time. People tease each other all the time, and fortunately, we don't kill each other most of the time. I find,
nice qualifier.
Well, but that's just real life, and these are real people. This is real life. I don't see the prosecution having a strong motive, whether it's the financial end of it or whether she was mean to him on occasion. It's just not strong for me.
Well, we are showing the beginning part of the prosecution's opening statements. Let's continue on because this is how their case further develops. Let's listen again. This is the prosecution's opening statements in the Claude Tex McIver case.
In addition to putting the gun in a plastic bag, 8 hours before the murder, the defendant asked Tanner McKinney to take Danny Joe Carter back to Atlanta. Now, Tanner McKinney and Samantha Watson are 2 young adults that come out to the ranch on a couple of Sundays out of the month in order to groom the horses and to walk them or to ride them. Tanner will testify that he lives in Athens. And he'll testify that he remembers the defendant asking him this because he knew that Danny Joe Carter lived in Atlanta. So he was confused by the request of the defendant to take Danny Joe to the opposite side of where he lived. You're going to hear from Dr. Suzanne Hardy, who was the treating physician of Diane McIver. And as she's working on Diane, she's trying to figure out what happened. Because at this time, she saw 2 holes in Diane. One in the front and one in the back. And she was trying to determine, was it 1 gunshot wound or was it 2? So she asked Diane what happened. And Diane says, I was holding it behind my back when the gun went off. Dr. Hardy will testify that she thought this sounded odd, so she asked her again, you were holding the gun? And then Diane says he was holding it behind my back. Then about 30 seconds pass, and Diane states it was an accident. Dr. Hardy continues to work on Diane and continues to try to save her life. And as time passes, she knows that Diane isn't doing so well and that she might not survive. And she'll testify that Diane looked at her and was like, I'm dying. And not wanting to tell her the truth, what she did was she said, you know, we're doing the best we can. You're getting the best care possible. But at this point, I'm going to need to intubate you. And to intubate is to put a tube down her throat. And she was like, after I put this down your throat, you won't be able to speak. And what she does is she asks Diane a question. She asks Diane, do you want to see your husband? And Diane says, no.
Do you want to see your husband? No. That's a common theme that keeps being brought up in the Claude Tex McIver case out of Atlanta about a prominent attorney who's on trial for murdering his wife. The question becomes, was this murder or was this a tragic accident? We know that he shot her from the backseat of a moving car, but he claims he fell asleep, had a gun in his lap, it went off, and it was all an accident. That's what we have to determine. So again, this trial is on break this week. It will resume next Monday, and we'll be covering it here on Law and Crime. So let's dissect a little bit more as we play the clips from this whole case. Again, I'm here with criminal defense attorney Jonna Spilbor. She was intubated.
Yep.
Okay? Tube put down her throat.
Yep.
She was given an option to speak to her husband one last time. She said no. What did you think?
I think we can't ask her what she meant when she said no. Did she say no because she was petrified and was more concerned about trying to stay alive? Did she say no because she hated him and didn't want the last person that she saw before she passed to be her husband? Because there's a big difference there. And we are never, ever going to know that because, unfortunately, she is dead. So what will the jurors make of it? That's the big question.
Well, what we do know is she said it was an accident. Diane McIver, the victim herself, said it was an accident. Now, here's another way to look at it, and tell me what you think. Even if this was an accident, and she knows it was his fault that he shot her,
right?
Why would she want to see him? You shot me. I don't want to see you. But then again, or if it was intentional, to keep him away, he tried to kill me. So if she said it was an accident, I feel it's more like my first explanation than it is the second one.
Well, listen, fortunately, none of us knows, and hopefully none of the jurors know, what it's like to be on death's door with a bullet hole through your back, right? We don't know. So it's really hard when people can put themselves in someone else's, when we can empathize with someone and we can use that to help come to a conclusion, that's one thing. I don't think any of us are going to be able to do that here because fortunately, we have not been in that horrible position. So again, it's an attempt to throw everything up on behalf of the prosecution to see what resonates with all 12 jurors, remember. It's got to resonate with all of them.
They started out with motive. The strategy was, let's present the motive first, explain why this happened, then we're going to go into what actually happened in the car, and we'll talk about that all later. But let's get more into the idea of what happened in the car. Gun safety. So we know Tex McIver, gun enthusiast, they brought all of his guns out. I don't know if we have a quick picture or B-roll of when they brought all of his guns out for the jurors to see. I think we'll work on that one. But the thing is, they brought all of his guns out for the jury to see. He knew about guns. He fired guns.
Yes.
He taught little Austin about gun safety. So how does a guy, I'll play devil's advocate here, how does a guy who knows so much about gun safety, how could a gun accidentally go off?
I'll tell you a very quick little story. Last week, coincidentally, I was sitting in a gun safety class at a facility. I sat down in my seat. I looked to the right. There was a bullet hole in the wall at a gun safety classroom. Because why? Because accidents happen even when you are skilled with fire. They're firearms. So it can happen to the best of us, unfortunately. So that doesn't sway me so much. That just because he was proficient with guns doesn't mean you can never have an accident. I think I'm proficient with my car. That doesn't mean I'm never going to have an accident.
That's very true. And ironically, they had a gun expert on the stand who accidentally discharged the weapon. So again, this is a gun expert. But it is something to think about, a man that knew so much about gun safety, because we're trying to understand what's going on in the minds of the jurors. And if a guy that knew the different modes the gun could be set into, why would, and I'll ask you this question, because I don't know if I had an opportunity to ask you this question, the million-dollar question. If we take what Tex McIver said on face value, and he says that they were going into a dangerous neighborhood and he wanted to take out his gun for safety, how could he fall asleep if he's in that kind of situation? How could he fall asleep while holding a loaded weapon?
That will most likely be explained in his defense because he had some sort of weird condition that made him violent when he fell asleep. And listen,
so you think they're going to bring in experts to talk about a sleep disorder?
Oh, they probably will. I think that's going to be a big part of the defense. And not for nothing, Jesse, again, let's just humanize everybody here. Have you ever fallen asleep in the back seat of a car? I've fallen asleep in a car when I'm not the one behind the wheel.
But not holding a loaded weapon when I'm trying to protect the other occupants in the car.
Well, and that may be true too. But I think it doesn't matter whether you have a loaded weapon on your lap or a puppy on your lap or my purse on my lap. If you're tired, you're going to fall asleep. So I don't know. Again, these are little tiny pieces. Are they going to add up to a conviction or not? For me, they're not. But now, I'm not in the jury box.
Here's another way you could look at it too. This is Atlanta. This is Tex McIver. He handled guns constantly. If you and I were to take out a gun, because I don't handle them, and I were to take out a gun to protect somebody in the car, my senses would be alert. I'd be up. But here's a guy who's so familiar with the guns that taking a gun out and holding it maybe was just common every day for him.
Second nature for him.
So falling asleep with it is not that big a deal. Do you think the defense will try to work that way?
It would be smart if they did. If they followed your lead and worked that way, I think it would be smart if they did, because it was not a big deal to him. It's not a big deal to somebody who is a gun enthusiast, who's familiar with guns. He had 40 guns. It's not like he was gingerly trying to manipulate it. That was not the case with him.
Yeah. All right, Jonna, stand by. We are still covering more of the opening statements in the prosecution's case because the prosecution is still putting on their case in the Claude Tex McIver courtroom. So what I want to continue playing for you is the opening statements by the prosecutor, and it really gives you a roadmap about where this case will go in their minds. Take a look.
And she didn't want to do that either. And what he did was he sent a car to her house to pick her up. And what Danny Jo had done is her and her husband, Tom Carter, left. And they went to the home of Dale Cardwell. And some of you may know who that is. He's a TV personality. He reviews businesses. And they went to his home. And he'll testify that when they got there, Danny Joe was upset. And when the defendant couldn't get a hold of Danny Joe, he repeatedly started calling Tom Carter. He's calling and calling and calling and calling. He's blowing up his phone. And he leaves 3 messages. And one of the messages, he tells Tom to tell Danny Joe to stop saying what she's saying, because it could end him up in jail. And what he tells him is, after you listen to this message, delete this message. And you'll hear it. What he did was, after he fired Bill Crane for not retracting the story, he hired Mr. Jeff Dickerson. Now, Mr. Jeff Dickerson is also a public relations specialist. And he's been in the business for a long time. You all may know him from seeing him on Sundays as part of the Georgia game. And what you will learn is that Mr. Dickerson was a longtime friend of my boss, Mr. Paul Howard, over 20 years. And what he'll testify to is that after he was hired by the defendant, he was called down to his lawyer's office. And the defendant and his lawyer were sitting at a table. Then the lawyer gets up to leave. And it's just the defendant and Mr. Dickerson. And what he tells Mr. Dickerson is, you can get this case dismissed. You can get this case dismissed. And if you do, there's a large bonus in it for you. And I won't mind if you share it with the DA. Now, ladies and gentlemen, at the close of all of the state's evidence, Mrs. Kara Convery will get up here, followed by Mr. Clint Rucker, and they'll perform closing arguments. And what the state will ask you to do is to return a verdict. And the only verdict that speaks the truth in this case is a verdict of guilty.
Welcome back to Law and Crime, everybody. So we are covering the Claude Tex McIver case in its entirety. It's this case out of Atlanta about a prominent attorney who's on trial for murdering his wife. Again, he shot her from the back seat of a moving car. He was in the back seat. Her best friend, Danny Jo Carter, was driving the car. Diane was in the front passenger seat. But he is claiming this was all a tragic accident and the gun went off itself. Now, that was the prosecution's opening statement. So let's dissect the conclusion of that with Jonna Spilbor. Okay, we learned a little bit more about the motive here. They're trying to say, okay, let's break it down. Why did it take Tex so long to get Diane cremated? I'm still confused by that.
So that was news to me. This is a little new fun fact here. And again, listen, he shot and killed his wife. His position is it was accidental. So when your wife's ashes are at the crematorium, would you be hesitant to pick them up? I don't know. I mean, does that prove anything? Does it prove or disprove anything? I don't think so. It's a weird fact. It seems kind of listen, if you're in a relationship and that person dies, are you going to leave their ashes at a crematorium when you had nothing to do with their death?
Yeah.
Probably not. It seems a little abnormal, but does it prove anything? I say no.
I think isn't there all they have to just try to show us some suspicious behavior? In your experience, when you can paint the defendant doing some suspicious things after a crime is committed, and we've seen cases before where there's guys who were just two-timing their girlfriend and they were hiding, they were not, they were using different phones and they were just doing something suspicious. They weren't trying to cover up a murder.
Right.
But here, if you can tie suspicious activity to the shooting, and we all know he did the shooting, that might be enough, no?
I think it just might be one more piece. So at the end of the day, meaning when this trial is over, how many pieces are the jurors going to have to try to piece together to determine whether the prosecution has met its burden beyond a reasonable doubt? Because that's another She said something else interesting, which I thought that, not in terms of the ashes. Oh, that's right. In terms of he sold her clothes, I guess, relatively
her fur,
soon.
her jewelry in the days after.
After her death. Now, and then the point the prosecutor made was he said he was doing this because that's what she wanted him to do, and she wanted these bequeaths distributed.
Yeah.
But to date, none of that has happened. However, we have an intervening issue here, and that is, in the meantime, he was charged with her murder. So I suppose he may have needed that money for his defense, and that's why nothing has got distributed.
I could be wrong, but I think he wasn't charged until 7 months after the shooting. And if that's the case, it still begs the question, why in the days after? Now, you could say, and I think the strongest argument put forward was by the defense, which we're going to play in a little bit, he sold all these items because of their value. You know, you sell furs in a certain month, otherwise they're not going to have value in the warmer months.
Right.
Now, the jewelry was an interesting perspective because we know her jewelry, and she had expensive jewelry. But Billy Corey, who was the boss of U.S. Enterprises, he was, you know, of Corey Industries, or that he worked with Diane, and he said to Tex, "Listen, take the jewelry, put it in a safe deposit box, give it to Austin later on when he grows up." But Tex didn't do that. He sold it. Now that's weird, or a little. That's not that. Not doesn't look so good for him.
Is it weird though? I mean, okay, and again, I'm in the defense camp here. Let's say that Tex McIver didn't have the loving relationship with Diane's godson Austin, right? And he's in a situation, and his wife passes, and he wants to sell the jewelry and make whatever money he can, and then at some point he knows he is also going to die, so some of that's going to end up in his will, some of his worth is going to end up distributed to people in his life anyway. I don't, listen, if he did not bring about her death, would it be weird? No. The only thing that makes this weird is that he's the cause of the death. If she died of natural causes, would it be strange for him to sell off her furs and her jewelry and do what he wanted with it? I say no. Well,
we know that he had a close relationship with Austin, but maybe the idea could be, and this is something that we talked about with a lot of guests, that when another spouse dies, and especially in this situation where he wasn't bringing in the kind of money that she was, I have to figure out what I'm going to do for cash if I sell her stuff. If he was trying to get a board seat at one point, he was trying to figure out how to collect her Social Security checks. He was trying to figure out if he could collect 401k from her, trying to figure out how he could get money into for himself.
Right.
It might not look so good, but if you take it in a case if she died of natural causes,
right,
he might say this is just something spouses do.
It doesn't look good because he's charged with her murder, but you're 100% right. In normal circumstances where one spouse dies, it has nothing to do with the other spouse, those are all common financial things that the surviving spouse is going to look at and want to secure for him or herself. It just is. And
what we keep talking about is the reaction from Tex McIver after Diane was shot by him. And the question becomes, was this normal behavior? Now, I think the defense, which we're about to play for you right now, this is the defense's opening statements. Listen carefully to when they talk about, is there a playbook for how a spouse should react when their husband or wife dies? I think this was a very crucial point. Let's listen in.
Good morning, ladies and gentlemen. My name is Amanda Clark Palmer. We just spent, I think, maybe 30 or 40 minutes listening to the state tell you all their theories and their reasons why they think Mr. McIver intentionally shot Diane McIver. And I want to tell you that you can just set all of that aside. There's really one thing that you need to know about Tex McIver and Diane McIver to know that he did not intentionally shoot his wife, and that is that he loved her, truly loved her, deeply loved her, and she loved him back. You are going to hear from multiple witnesses that they had a relationship that people were envious of, that they seemed like lovebirds even after 10 years of marriage, that Tex adored Diane, that she loved him, and that they were clearly proud to be married to each other. Nothing the state will present to you will prove that this was not an accident. They go on I-20, and when they get to the connector, they hit a traffic jam. There was some construction going on the interstate, so traffic was really backed up. At this point in time, Tex has fallen asleep in the backseat of the car. He fell asleep on the ride from Longhorn into the city. And so Diane is the one who tells Danny Joe to get off the interstate. Diane is familiar with that area down there. She knows how to use the surface streets to get from the Edgewood exit area back up to their condo in Buckhead. So she is giving Danny Joe the directions. They get off at the Edgewood exit, as I say, and at that point in time, Tex wakes up and he looks around. He says, "Girls, I think this is a bad idea," or "I think this is a bad area," something like that.
As we recap the Tex McIver case out of Atlanta, which is currently on break, it's coming back next Monday, we're replaying everything from the beginning. We played the prosecution's opening statements, now we're playing the defense's opening statements, but there's really one lingering question. Was this an accident or was this murder? And I think the best way to explain this is to try to understand, if this was murder, would you do it like this? Let's bring in Jonna Spilbor. Okay, we talked about this. I talked about it with other guests before. We talked about it in the break. If you are going to kill your wife, would you do it in this manner? In a public space, in a car,
with a witness.
With a witness, and you don't even know by shooting Diane in that way if she's going to die.
Yeah. See, and that's another common sense approach to this, right? We have to put ourselves in these shoes. If you're plotting to kill your spouse, I suppose there are far better ways to do it, for lack of a better word. In other words, to not get caught. They lived on a ranch. There's probably plenty of opportunity for him to kill her in a less obvious manner, I suppose. Now, we're not murderers, so... But I think that does help the defense, because it's just a situation where we were talking in the break. Like, did Tex McIver insist on sitting in the back seat, or was it just, they naturally got in the car, the way they were getting in the car with somebody driving, and his wife decided to hop in front? It's not like he insisted on sitting in the back. And then at the precise moment, he asked for her to hand him the murder weapon. I mean, there is a logical progression to this stuff. He didn't ask for that gun. It stayed until they got to a certain neighborhood. It stayed in the glove compartment in a bag. To me, that makes sense. What the defense is trying to say is he had no intention of bringing that gun to kill his wife that day. He had the gun for another purpose.
But under the law, couldn't he have formed that intent seconds before? Maybe she said something to him that he didn't like. Maybe he thought about his life in that drunken state. Maybe something ticked him off. And if he decided to intentionally shoot his wife, he didn't need planning months before. He didn't need to do Google searches about how to do it. He didn't have to premeditate it and plan it and say, hey, I want you to sit in this seat. If he thought about it, deliberated on it, and did it in seconds before, is that enough?
The law says that you can deliberate in seconds, yes. But let's look at this like real people for a minute. He's got no history of violence. He's got no criminal history. He is a prominent attorney. You cannot keep your license to practice law if you do strange things like commit crimes and have domestic violence reports every other day. You can't do that. So let's presume that he was a sane human being, and it would take a heck of a lot more than driving into a bad neighborhood to enrage him to the point where he wanted to intentionally, with premeditation, kill his wife from the backseat of somebody else's car.
And what really hurts the prosecution's case, and they keep calling witnesses that hurt their case, including lead detective Darren Smith, we'll talk about that a little bit later. But I would say the majority of the witnesses said, if not that they had a normal marriage, they had a happy marriage, that they loved each other. I didn't see them really get into fights. Sure, she teased him a little bit here and there, but it was all in good fun. It was all in good taste. I didn't see anything. He was abusive. She was abusive. Nothing that would indicate that there was anything other than a normal marriage.
Right. And I love when you juxtapose the prosecution's opening statement, where she very methodically went through what you're supposed to do, went through the entire case and all the evidence that she's going to show to prove that he intentionally did this. And then you have the defense attorney come up and says exactly the opposite. They had a great marriage. There was nothing wrong with them. And people were jealous of how well they got along. And I love that about the law, because you know that in those seconds after the prosecution sits down from her opening statement, that the jurors are saying, wow, this guy's guilty. And then seconds later, you have the defense come up and say, hang on a second, folks, we have a different version here.
And I'm so glad you said that, because Amanda Clark Palmer, who's one of the defense attorneys here, did a remarkable job in these defense openings. Again, when we were following this case, when it first came out, and Mr. McIver was charged with involuntary manslaughter and reckless conduct, it seemed to be a open and shut case, even when they upped the charges to murder. We knew he was the shooter. We knew it happened in a car. How can you explain this away? But Amanda Clark Palmer, and you got to give kudos to the defense team here by putting her first, really articulated and told a story that was relatable and that was believable. And I think the prosecution will have a really hard time trying to argue away. Here is a continuation of some of her opening statements. Take a look.
Detective Smith, okay, did you guys take turns driving down there, or did some of you drive more than others? Mr. McIver said, I think I drove. Detective Smith said, okay, you're like me. I like to drive when I go. Tex says, I like to be in control. That's the context of that statement. He's just talking about when they drove down to the ranch, that was why he was driving. It's not some nefarious statement he made in connection with explaining what happened on September 25th. So that's September 28th, 2016. Importantly, Tex McIver tells Detective Smith exactly what happened. He tells them he was holding the gun when it went off. He tells them Danny Joe was driving the car when he went off. The events that I just relayed to you about what happened on September 25th, that is what Tex McIver told the Atlanta Police Department on September 28th. The evidence will not show that the gun went off magically or by itself. It was in Tex's lap, in his hand, when it was discharged. And when we say accidental, what we mean is that the shooting wasn't intentional. And I think there are kind of 5 key takeaways you'll see from the forensic evidence that will show to you that this was not intentional. First, as I said, the gun was resting on Tex's lap when it was discharged. Second, it was fired from a sideways position. That's what I was demonstrating for you before, that when Tex was kind of, laid back in the car, sort of slumped down, the gun is in his lap in this sideways position. It's not pointed upright. It's not like this. It's not back by his hip. It is in his lap when it is fired. The gun never comes out of the plastic bag. That is one thing that we can say definitively from the forensic evidence. They can tell that it was fired from within the plastic bag, but was accidental. So we looked at the gun already. So here is what's shown in these pictures is the passenger seat of the Expedition. This picture in the bottom left corner with the number 2 on it, that's the back of the seat. You can see that that's where the bullet entered the seat. This picture over here on the right, and I hope you all can see it, shows you that there's a lot of kind of mechanical workings on the inside of the seat. I think those relate to maybe the seat heater or maybe the motorized seat. I don't know. But the point is that this bullet passed through all of that before it came out of the front of the seat, which is that top left corner where the number 3 is. And I'm not trying to be crass or glib about this shooting, but if you were going to intentionally shoot someone because you wanted to kill them, this is objection, Brian. Argument.
So if you want to share what you think the evidence will show, you're welcome to do that. And then at the end of the proceedings, you're welcome to say, based on this, I think it's shown or failed to show X, Y, or Z.
The evidence is going to show to you that it would be just as likely that this bullet might strike the mechanical workings of the interior of the seat and deflect. Maybe come back and hit Mr. McIver. Maybe go through the seat but deflect and go off at a different angle, go through the radio, go through the side of the car. The evidence is going to show you that it is not a guarantee or even likely that you would be able to kill somebody in this method. that's why the shooting was accidental and not intentional.
That's Amanda Clark Palmer delivering the opening statements for the defense in the Claude Tex McIver case, a prominent attorney who's on trial for shooting and killing his wife, Diane McIver. And you really hear the defense saying this was an accident. If you look at the way this gunshot happened, if you look at the crime scene, it really was an accident. Jonna, that was a good point. Didn't he? If he wanted to kill her, he would have raised his hand and shot her directly in the back of the head. But the way the positioning was, we know it was an upward shot. We know it was through the plastic bag.
Right.
And I talked about this earlier. There was no guarantee that that shot would have been fatal. I mean, let's say he shot her and she survived, and he didn't know that. So again, if it's his intent to kill her, wouldn't he have fired the gun multiple times? You know what I mean?
Or would it have been higher, like, toward the headrest? Which goes along with what we were saying previously. I mean, there are far better ways to try to kill your spouse successfully than this. And when you look at where that bullet came through the passenger seat, it's logical to presume that that gun was really toward his lap. Like maybe he was moving it on his lap, maybe he was repositioning on his lap. But it wasn't where you would think you would aim behind a seat at somebody if you were intentionally trying to end their life.
Yeah, that's an image right there, a 3D reconstruction of the actual car. Now, just imagine Danny Joe Carter was driving the car, but you see that black and tan. That's where the gray where the gun was actually taken from. The gun was given from Diane to Tex, which is an interesting perspective too. I think it's interesting that the victim handed the defendant the weapon. She knew. She handed him the victim. Does that play into this at all?
And it is a little bit ironic, but it tells me, this is what it tells me. She wasn't afraid to be in the car with him with a loaded gun.
Right.
She was not afraid of him. She did not fear for that. So she, otherwise if she did, if they were having all these struggles and they had this horrible relationship and she hated him and he hated her, you're in the car, you're just going to, here you go, hon, here's the loaded gun.
Yeah, but here's a flip side of it, because I like playing devil's advocate. You could say, she trusted Tex. She knew he could handle a firearm. And then it discharged, and it was an accident. What's not adding up there? Now, but here's an interesting perspective, though, and I want to talk about this. We talked about it in the break. He was initially charged with reckless conduct and involuntary manslaughter. Those charges were up to murder, and he also faces other charges, including aggravated assault, as well as influencing witnesses, which we'll talk about in a minute.
Yeah.
But could they find him guilty of the lesser included of involuntary manslaughter and reckless conduct?
So this is where the rubber's going to meet the road at the end of this case, when the jurors get instructed as to what they're going to have to find, right, in order to convict him. Now, if I'm in the defense camp, and I am, but if I'm at the defense table, I'm going to argue, if the evidence stays the way it is, if there's no smoking gun, I don't mean that facetiously, I mean, I would argue, do not give these jurors the opportunity to find a lesser included offense of involuntary manslaughter, which I think is appropriate here. I do think it's involuntary. I think it was reckless. It's reckless to have a loaded gun in a passenger compartment of a car if you have sleep problems or what have you. Let's just put that aside. But I would argue, as the defense, the jury should not get that instruction because it completely contradicts what the prosecution's case is. The prosecution is making no bones that this was not an accident, this was not reckless, this was intentional. And they went through it. They go through the financials, they go through the relationship, they go through all of that. So for the prosecution to argue that they should also get the lesser included offense, which has nothing to do with the premeditation or the motive, nothing, would run afoul of what the prosecution has been floating this entire time.
What's a great perspective about this, or what they'll probably kick themselves about, is if they do not get that lesser included.
If the prosecution doesn't get it?
If the prosecution doesn't get it, and if he's found not guilty of murder, they would have had a slam dunk case if they went involuntary manslaughter and reckless conduct. I mean, this shouldn't have happened. This was reckless.
Not only would they have had a slam dunk, they probably wouldn't have had a trial, because Tex McIver probably would have pled guilty to a lesser offense like that, knowing to avoid a trial, to possibly avoid jail time, if it's possible to avoid jail time in that state.
How do you separate an accident from reckless conduct? How do you even do that?
Well, and that's the problem in this case, right? And I think as a person, you have less of a problem admitting that you had an accident, you made a mistake, versus admitting that you did something intentionally. It means night and day. So there's no way Tex McIver could have pled to any sort of intent here, because his whole theory, and he's sticking to it, and I don't blame him, is This was just a horrible accident.
Right. You don't hear them say, Tex was stupid, Tex made a mistake,
right.
Tex, you don't hear any of that. They say what happened, they said it was an accident, but you don't hear, they said, well, he should have, Tex McIver, my client, is guilty of not taking enough precautions, he shouldn't have fallen asleep. You don't even hear that flavor of it either, because they don't know which way the jury instructions are going to go.
And the prosecution right now basically went all in, and it could come back to bite them, because without that instruction, like I said, if the jurors had to make up their mind today, which they don't, but if they did, I don't think that they can prove the premeditation and the intent beyond a reasonable doubt. I don't think they can find that. And if the evidence stays on that level, it'll be a boon to the defense if the only instruction is for that first-degree murder.
Yeah. All right, everybody, let's continue showing you the defense's opening statements in the Claude Tex McIver case. Again, this trial is on break this week. That's right, it's on break this week, but it will come back on Monday. That's right, and we're going to cover it here live on lawandcrime.com. So let's continue playing and analyzing this amazing case that's really captured the nation's attention, and we've been covering here minute by minute. This is now the continuation of Amanda Clark Palmer. She's the defense attorney, or one of his defense attorneys, providing the opening statement. Take a look.
Most importantly, there was a witness who was Diane McIver's best friend. Danny Jo Carter had known Diane McIver for a long time before Tex McIver met Diane. And the evidence will show that it's inconsistent with an intentional killing to shoot Mrs. McIver in front of her best friend. You are also going to hear evidence that Tex has a sleeping disorder. It's called REM behavior disorder. It is abbreviated as RBD. So most of us, when we fall asleep and when we dream, kind of a curtain comes down in our mind. So that if we're dreaming that we're running or jumping or whatever, our body is not physically acting out what we're doing in our dreams. People who have REM behavior disorder do experience physical movement while they're dreaming. They can jab and kick if somebody else happens to be in bed with them. Because they have whole body jerks. They can have whole body jerks when they're experiencing a dream and they have REM behavior disorder. Mr. McIver has a well-documented history, going back more than a decade, of having REM behavior disorder. And I expect that you will hear evidence about that. I expect you will also hear about something called confusional arousals. And I'm not going to get too far into the details of that with you, but confusional arousals are also sometimes referred to as sleep drunkenness. It's when somebody is startled awake and they are disoriented as to where they are, and they act in a way that doesn't make sense or is inappropriate, maybe even violent. And most importantly, when somebody has experienced a confusional arousal, they can have amnesia, which means they may not be able to recall what exactly happened when they were woken up from their sleep. So I expect that you will hear evidence about that. We don't dispute that both Diane and Tex were contemplating making changes to their will. They both had a will that was drafted and executed in 2006, which was executed either before Austin was born or it was executed at a time when he had just been born. So he hadn't really, he was in their lives, but they hadn't developed that close connection with him that they both developed as Austin got older. So Austin is their godson. They both loved him dearly. It's not as if Austin was only Diane's godson. Both Diane and Tex treated Austin as if he was their own child. They both loved him dearly. They both wanted to provide for him in the event that either one of them died. This is not something that Diane was contemplating doing all by herself. And that's another reason why Tex would not intentionally shoot Diane, because he knows that Diane loves Austin, and Austin loves Diane dearly, and he would never take her.
We are continuing to break down the Claude Tex McIver case as it is on break until next week. Now, again, this is the defense's opening statements. This is Amanda Clark Palmer. She's delivering a very eloquent, easy, just a really straightforward opening statement that I believe resonated with those jurors. It definitely resonated with me and people, everybody who's been watching it. So let's talk a little bit more with Jonna Spilbor about this. Okay, so as we go in, we're listening to a little bit more and more and more. I thought this was an interesting perspective. The idea that he wouldn't kill Diane because Diane loved Austin and Austin loved Diane and he loved Austin. But how many times do we see spouses killing another spouse when they have children together? That idea of, I'm not going to be so selfish to take away this person because I know what they mean to my child or they mean to someone that I'm cared about, that was a little bit of a stretch, no?
I don't know if it was a stretch. I think maybe the point is going to be a little bit lost on the jurors because I believe what she's, getting at is, look, this was a loving couple. They were both contemplating changes in the will because, much has been made about Diane wanted to change her will and just didn't get a chance to do it. And when she changed her will, it was all going to go to Austin, or not exactly, but you know what I mean. And the defense is trying to say, wait a minute. They both loved Austin. They both were going to provide for their godson when one of them passed. And I think it's quite common that when you have somebody that you want to leave your stuff to, when one spouse dies but the other spouse is still alive, the other spouse still has a right to that stuff until he or she passes. So it would have been perfectly okay for Tex to leave the remaining part of the estate when he passed to Austin, and maybe that's what they were contemplating when they were going to change the wills. Again, we won't know because Diane died before that was able to occur.
What do you think about the will? So we know that she had a will before Austin was born, or maybe right before he was born in 2006. She never updated it. And then there's this whole conversation about a secret second will that no one can find, no one can produce a copy of, and the prosecution even seems to say or imply that Tex was trying to find it or try to discard it. What did you make of this will situation? The
prosecution really should not have been allowed to bring that up because it is pure speculation without any actual evidence that a second will existed, and further evidence that somebody destroyed it or hid it or is secreting it. It really is prejudicial, and the jurors should be instructed to completely discount that information. They have an actual will. They have no solid proof that there was a second will or that somebody did something nefarious with it. Again, the prosecution got more leeway than I would have given them if I were on the bench in this case.
We know that her intention, and she wanted to leave the Putnam Ranch to Austin, but we just heard from Amanda Clark Palmer that they had rights of survivorship to that property, and if one died, it goes to the other. So that's just the way that the situation worked, and it just happened that she died at that point. I mean, but then again, you could look at it from the other perspective and say, well, he killed her before she could change her will. That ranch went to him, and as much as if it was an intention for Austin to get the ranch, because he could have gotten the ranch, Tex, and said, you know what, Austin, Diane wanted you to have this. I know it's not left in a will, but I'm going to give it to you right now. I'll get an apartment somewhere. What did you think?
Could he do that? Sure. But the theme of this case, and we keep hitting it and hitting it, the theme of this case is all the things that happen with respect to the estate and what have you are things that are so common when a spouse predeceases another spouse. And I'll bet you one of the things that the jurors aren't hearing right now is Diane probably contemplated that she was going to live longer than her husband. Why? Because A, women do. I mean, statistically, we live longer than men. I think Tex might have been a couple of years older than her. I'm not exactly sure how much. So statistically, her stuff was not going to go to him because she was going to outlive him. So when we try to get into Diane's brain, which is what the prosecution is asking us to do, even though we can't, you have to remember that, like we've been talking about, a lot of this stuff is common estate planning stuff. Nothing nefarious. Nothing nefarious.
I'm glad you brought up the idea of prejudice. Obviously, the test is, does evidence have more probative value versus prejudicial value? We learned on Friday something very interesting happened, and I want to let our viewers know. So on Friday, which was day 14 of this case, an argument ensued outside the presence of the jury concerning whether the prosecution could present evidence from an emergency room doctor that Tex McIver talked to him in a racial manner. That's right, in a racial manner, when doctors approached to notify McIver that his wife was dead. Now, the judge ruled that the evidence was more probative than prejudicial and that it could come in, but there's a caveat that he would not allow prosecutors to hype it up or draw a lot of attention to it. Jonna, does that make sense to you?
Nope. Not even a little bit.
How is that probative?
That doesn't, well, first of all, I think it is far more prejudicial than probative, number one. Number two, what does that mean? I guess we're going to find out what it means to talk to somebody in a racial manner. In other words, are we going to hear, did Tex McIver do something horrible, like use a racial slur in talking with the doctors? We don't know that yet. And three, how do you instruct prosecution to not hype it up? It's either evidence that's getting in and the jurors are going to hear it, or it's not. Hyping it up?
What does that even mean?
Exactly, what does that mean? Listen, whatever happens in this case, if the defense has an opportunity to appeal, that will certainly be one of those issues.
I assume that it has something to do with the idea, okay, this Black Lives Matter comment that was made by Tex McIver and that he tried to change it. If you can try to say, look, they were going into a bad neighborhood. He was a guy who assumed the bad neighborhood was filled with maybe Black Lives Matter protesters. That's what originally he said, or something he said. And you can somehow equate, well, here's a guy who has racial tendencies or some predilections towards a certain set of people, and maybe that's why. If it's important to understand, look, he showed these kind of biases or these views earlier in the night, and now he's showing it in the hospital room. Again, I'm struggling to attach the two, so I don't know how the judge, Judge McBurney, thinks that has probative value.
You know, and perhaps it would have probative value if Tex McIver was accused of shooting somebody of another race, but that's not the case here. He's accused of shooting his wife from the back seat of an SUV, so I don't understand how it is at all probative. I really don't. The only thing that it might, here's the prejudice. Let's say he did say something that was racially motivated to the doctors. That has nothing to do with what happened, but in the eyes of the juror now, Tex McIver doesn't look like a saint. He doesn't look like a nice guy. He looks like a racist. And that's going to be unfortunate because race has nothing to do with this accident/crime, depending on how you're looking at it.
Unless he said something about what happened that night and said, look, we were entering into a bad neighborhood with... And maybe he said something to describe a group of people. I don't know. And that could maybe be probative because it shows what happened during the shooting. Again, it's an interesting perspective. But Judge McBurney, before we go to, I want him to continue playing the defense's opening statement, he has a relaxed style. He has a very laid-back style, very amicable, seems to kind of let things go a little bit. What did you make of his style so far as you watch him in this case?
I think he's been giving way too much leeway to the prosecution, laid back or not. I really do. And I think this call on what Tex said racially, for lack of a better word, to doctor is a wrong call. I think he's made a bad call. Listen, the jurors are going to be instructed that they are not to take any cues from this judge. Every juror in all the land is instructed about that.
Yes.
I like a laid-back style. I am loving the style of the defense attorney who gave the opening statement. She kept this so simple and so relaxed, and jurors cannot help, not to get off the judge topic for a minute, jurors, I think, sort of, the defendants live vicariously through their attorneys. If a jury doesn't like, if you have a bombastic attorney and spit's flying out of his mouth and what have you, that can figuratively get on the defendant and make the jurors not be amenable to liking that person or not humanizing that person. Here, you've got somebody who, like you said, very eloquent, very simple, even-keeled. You like her, so if you like her, there's a good chance you're going to like her client.
Well, I do like her, and I thought she gave a great opening statement, and that's why we're going to continue playing for you right now. Again, this is some more of the opening statements from the defense in the Claude Tex McIver case. Take a look.
Let me also address something that the state brought up in their opening, which was this auction that happened after Diane passed away, where her belongings were sold to generate money for the estate. I expect the evidence will be that that was done on the advice of a lawyer named Stan Smith, who I expect he will come tell you that he was the one who said we need to hold the auction of these items and we need to do it now. The reason being, there's kind of two reasons that go along with that. One is that in particular the furs are obviously a winter item. So you are more likely to get more money for the furs if you have the auction when it's cold than if you do it in the middle of the summer. The second is that just kind of generally clothes sort of lose their value over time. So you don't want to hold on to clothes and sell them at the next cold season because they may not generate as much money when they're sold. So I expect that you will hear Stan Smith come tell you those two things, as well as tell you that it was his advice to hold the auction when it was held in I believe, January of 2017. And the auction was held because Diane made specific requests in her will. There were people that she identified that she wanted to receive money, people other than Tex McIver. And the money needed to be raised to satisfy those requests. And I am confident we're going to be diving in to the details of what was in her will, how much money was raised, what was in her bank accounts. So we will have plenty of detail on that as this trial goes on. So let me finally touch on Jeff Dickerson. Jeff Dickerson comes into the picture kind of later in 2016. Jeff Dickerson is going to tell you that at some point Tex said to him, if you can get the charges dismissed, Tex had been arrested and there was no indictment at that point in time. But if you can get the charges dismissed or get the DA not to bring an indictment, there's a success fee in it for you. This was not a serious comment. In fact, it was a stupid comment because it could be easily misinterpreted like it is now. Tex did not mean for Jeff Dickerson to run off and try to bribe Paul Howard. And the evidence is going to show to you that there are a lot of reasons why that's not true. First of all, he doesn't say to Jeff Dickerson, go tell Paul Howard that I'm going to pay you a success fee if you can get the charges dropped, and that you'll share it with Paul Howard. That's not what he says. Second, Tex never followed up with Jeff Dickerson. Hey, have you had that meeting with Paul Howard yet? Did you tell him about the success fee? When are you going to have that meeting? Is something on the calendar yet? None of those conversations ever took place. They never discussed the amount of this supposed success fee.
We're discussing the Claude Tex McIver case here on Law and Crime Live, and basically we have to analyze what is the defense saying right here, okay? We know the prosecution is saying that Claude Tex McIver, a prominent attorney, intentionally shot and killed his wife. But the defense is saying that this was all a tragic accident. And not only that, because we don't talk about it as much, but we definitely should, Mr. McIver is not only on trial for murder, but he's also on trial for 3 counts of influencing witnesses. And that is what the defense is talking about right there, that Tex McIver intentionally tried to cover up this crime. Let's bring in again Jonna Spilbor. We don't talk about the influencing witnesses charges as much as we should. He faces 3 counts, and right there was the one about Bill Crane, and there was also Danny Joe Carter and Tom Carter. So with Danny Joe Carter, we know he had a conversation, or it's alleged that he had a conversation with her at the hospital and said, you know what, I don't want you to get involved in this, okay? I don't want you to tell anybody about it. Just say that you weren't even driving the car, that you came here later. I know how these things work. Now, I'm not going to lie. This is an attorney. Probably shouldn't have said it. No. But is that an influencing witness charge?
Yeah. I really do think it is.
So you think he might be found guilty of that?
He could very well be found guilty of that unless the defense has some alternate theory that A, that's not exactly what he said, although we already heard from Danny Joe Carter, or B, there was some other reason for him to say it. It wasn't in the context that it was brought out on prosecution. So there's some splaining to do on that one. And again, you know, I don't know if he said it, why he said it. Did he say it in an attempt to, look, how do you cover up a crime, Jesse, when you committed it, if it were a crime, the act? How do you cover up an act when you committed it with that person you're trying to influence behind the driver's wheel of a car? Like, you can't, like, there's no getting around that.
Well, the idea was, is this a guy who's trying to cover up a murder, or is this a guy who knows the legal system, knows he did something wrong, he was reckless, and trying to cover up a little bit there? It doesn't really matter. If he's trying to cover up an accident, he's trying to cover up a murder, it's really the same thing. So when you look at the Danny Joe Carter charge, that's not good if the state really did prove beyond a reasonable doubt that that's the conversation that he had.
If that conversation occurred, yes.
You can also try to see how they'll tweak it a little bit and say, look, she was a family friend. He didn't want her getting involved in this. He didn't, but he never said lie. He never told her to lie. So that's a big point.
And it's a good point, but are the jurors going to look at it like he was definitely trying to influence? You can influence without telling somebody to lie, right? You can influence by having somebody not say anything when they have an obligation to say something, although Danny Joe Carter didn't have an obligation to say anything. So it's going to be interesting. Plus, I think the jurors might, at the end of this case, are they going to feel sorry? I mean, do you think it's possible for them to say, this man accidentally killed a woman that he was in love with, now he's sitting in jail, he's accused of her murder, we're going to cut this guy a little slack? I mean, it's possible.
That's a good point. And you look at the Tom Carter one, where he told him, delete this voicemail. Telling someone to destroy evidence
is bad.
Is really bad, especially when you have an attorney who should know better.
Right, especially when you have an attorney who should know better. And like I said, that is not good. And it's hard for us to wrap our minds around it because we've never been in that position, and I don't know, hopefully we never will be. But I think, listen, if he has to go to jail or if he's convicted of those counts, wait a minute, break it down like this. Hang on. Maybe the defense strategy will be you can only convict on these let's call them lesser counts, if you believe that he actually committed a crime. If there were no crime here, then you can't convict him on influencing these witnesses because maybe the statute says it pertains to a crime. I don't know. I have to read the statute in Georgia. Maybe they're going to parse it out legally like that. Or they could put their hands up and say, go ahead and convict him of these lesser counts, but you can't convict him of the top count of murder.
That's an interesting. So if this really isn't a criminal offense,
right? What did he cover up?
That's an interesting perspective, and maybe that's why that's what I like about this case in the sense it's split up into different factors.
Yeah.
And you might have a murder. There's one set of stage. Will this be murder? Will this be an accident? Will this be involuntary manslaughter? Then what happens to the influencing witnesses charges as well? And let's not forget, he's also charged with aggravated assault and possession of a firearm during the commission of a felony, but they are all tied in together. Yeah. Finally, we heard a little bit about Bill Crane, who is this PR specialist, and how Tex McIver allegedly tried to have him retract a statement that Tex first made about the Black Lives Matter movement, and then even this conversation that, hey, if you can get the DA to drop this, you know, there might be some money in it for him. I thought Amanda Clark Palmer did a good job of trying to downplay that part.
Yeah, and I agree. And here again, look, maybe if you try to get somebody to retract something you said about a Black Lives Matter movement or event, it could have been he was saying that because he was simply fearful. It doesn't mean that he was, you know, trying to influence anyone or change the outcome. He was simply fearful of that. And I can understand how that would make sense. Plus, look, we know, because we're attorneys, but some people don't, that when something like this happens, you really should just shut up. Whether you're, you know, especially if you're going to be accused of participating or committing a crime, just be quiet. Don't come out and talk to the press. You talk to a lawyer. You don't talk to the press or anybody else until you've had a chance to reflect, calm down, and get some legal advice. And it doesn't sound like he did that.
Yeah. Well, he this idea that Stephen Maples, who was his attorney at the time, came to the hospital. That is a central character in this story. I'm very curious if he'll be actually called to the stand. But then again, if he was his attorney, what can he actually testify to?
Not much.
Because of the attorney-client privilege. But it's interesting when you see that he... Do you like the idea that he was lawyering up immediately?
I like that idea because I'm a lawyer and I understand the value in that. People who are not lawyers, and I get it. They always think, well, why lawyer? If you didn't do anything wrong, why are you lawyering up? Well, because I didn't do anything wrong, I'm lawyering up. You know, there's a phrase that I from time to time say: defending the guilty is easy. Defending the innocent is really hard. And for that reason, you should lawyer up, especially if you're innocent.
Yeah, because you don't know what you're going to say and how it could be used against you, which is really happening to him here. The conversations that he had with different parties in relation to this shooting is coming back to haunt him right now in this trial, and his defense team is having to work very hard at explaining away a lot of this behavior. Here's the conclusion of the defense's opening statements in the Claude Tex McIver case. Take a look.
Tex wasn't trying to bribe the DA. He wasn't attempting to commit a crime. Jeff Dickerson, I think the evidence will show, didn't think that Tex actually meant he ought to go bribe the DA, because Jeff Dickerson doesn't go tell Tex's lawyers, hey, you know what, your client just told me that I needed to go commit a crime, that I needed to try to bribe the DA. He doesn't go tell Paul Howard, hey, Tex McIver just tried to get me to commit a crime. He doesn't tell anybody about this conversation until some 14 months later. And, most importantly, Jeff Dickerson doesn't quit working for Tex. He continues to be paid about $3,000 a month. That shows he didn't think Tex was seriously intending that Jeff Dickerson go bribe the DA. This some 14 months later, that Jeff Dickerson is having what appears to be a casual lunch between friends with Paul Howard when he is no longer working for Tex McIver, and somehow this comes up. Why Jeff Dickerson mentions it to Paul Howard, I don't know. The thing I know that the evidence will show is that it was not an intentional statement. It was not a serious attempt to bribe the DA. It was a comment that has been misinterpreted. The evidence is going to show that Tex shot Diane accidentally in front of her best friend, and that this is inconsistent with intentionally wanting to shoot and kill Diane. The evidence is going to show that when the gun discharged, they were by Piedmont Park, not somewhere out on I-20, not out in Putnam County, where the ranch is, where it's remote and there's no hospital nearby. The evidence is going to show that the gun was held sideways, that it was shot through the plastic bag, as I said, that it was shot through the car seat, which had all the interior mechanical workings, that the evidence will show the bullet could have been deflected or slowed down or come apart. The evidence is going to show that the gun entered Mrs. McIver's back in her lower to middle back. And then finally, the evidence is going to show that Tex was relying on Diane's substantial cash flow and income every month, and there was no financial reason for him to cut that off. The evidence is going to show to you, ladies and gentlemen, that Tex loved Diane and Diane.
It can sometimes be a bit frustrating being an attorney in the courtroom, dealing with procedure. Again, I'm here with Jonna Spilbor. You see that. What's going on there?
I'm getting frustrated for this defense attorney. It is very unusual for there to be objections in the opening statements, and also pretty unusual for there to be objections in the closing arguments, but more so in the opening statements. And this prosecutor seems to be making a habit of it. The defense attorney is handling it very well. I like her point when she just was objected to in this segment, and she said, Your Honor, how is my saying that any different than the prosecution saying, and you must find him guilty? I completely agree. It's not argument. I mean, you're allowed to make a little bit of argument. You're not supposed to make argument, but you can get away with that last line. It's not going to throw anybody off. But the prosecution, by making these objections, is trying to throw the defense attorney off. That's obvious.
Exactly. All right, everybody. So we are recapping the entire Claude Tex McIver case here on Law and Crime because the trial is off this week. It will be back on Monday. But before we recap everything, we have to talk now about the prosecution's case. So we saw the prosecution's openings. We saw the defense's openings. Now let's listen in to the very first witness that was called in the Claude Tex McIver case. Her name is Janie Calhoun. She was a friend of Diane McIver, the victim, and also their neighbor. Let's begin her testimony from when this case first began.
Yes.
And how do you recognize each of those photos?
The first one is Diane McIver. The second one is Diane McIver. The third one is Tex McIver. Fourth one is Diane and Austin Swall, their godchild. And the last one is Diane and Austin, their godchild.
And each of the photos that you have in front of you, are they a fair and accurate depiction of the people that you just told the jury about?
Yes.
All right, this time the state's going to tender what's been marked as 1 through 5 into evidence.
No objection?
Correct.
Okay, they're admitted.
Is that Commissioner Hodge?
You do.
Tell the jury who is in State's Exhibit 1.
Diane McIver.
And you told the jury that the two of you were like sisters. Tell them how your relationship, how is it that you first met Diane?
I had met Diane probably years back in the early 90s, but it was because of the legislature and Billy Corey, her employer. I had met her, but I did not know her personally. When we moved into our condo, which is next to theirs, that was in 2005, the end of 2005, and I met her again at that time, and then in 2006 we got to be really close. We spent a lot of time together.
And what was it about 2006 that brought you and Diane to be close friends?
Because we were neighbors, I think. We went out to dinner some, and just she and I were both a lot alike. We both were hardworking business people. We both grew up very poorly and worked our way up to where we're at in our positions. So it's we had a lot of the same things in common.
And as you continue to become closer to Diane and get to know her, do you also kind of get an understanding for who she is as a businesswoman?
Very smart. She was very strong. She had built Corey Industries, I felt like, to the point that it's at right now.
And you mentioned Billy Corey before. Tell the jury, who is Billy Corey?
Billy Corey is over, I believe it's more called U.S. Enterprises, but most everybody looked at it as Corey Industries.
And in your time getting to know Diane, did you also know the defendant, Mr. McIver?
Yes.
Tell the jury how you first met the defendant.
I first met Tex back in 1997. Got to know him a lot better when he and Diane got married.
And did the couple have any children that you know of?
Tex and Diane not together, no.
Did Diane have any children from her previous marriage?
No.
What about Mr. McIver?
Yes.
Do you know how many?
He had 3 children.
Okay. And do you know about how old they were in, well, let's talk about 2016. You know about how old his children were?
I have no idea. I really don't.
That's allowed. You mentioned Austin. Tell the jurors, who is Austin?
Austin is Diane and Tex's godchild.
And when did Austin come into Diane's life? You know.
Right after he was born, and that was in 2007.
Welcome back, everybody. That's Janie Calhoun. She's a friend of Diane McIver, a neighbor of the couple as well. We're trying to analyze and dissect the entirety of the Claude Tex McIver case because it's on break this week. So let's analyze what's happening here. Again, I'm here with criminal defense attorney Jonna Spilbor. When you look at witnesses who knew victims and the defendant in cases, murder cases, and when the spouse is charged with the murder or the boyfriend or the girlfriend, it's interesting to see these people that knew them best. What do you think's going through their minds? Like, how did this happen? I can't believe it. You know, again, especially when you have a case like this where it seemed like a good marriage.
Right.
How shocked do you think these people are?
Well, none of these witnesses for the prosecution who knew them are coming up and saying, I knew it was just a matter of time before Tex killed her. Like, nobody is saying that. The prosecution is really going in this roundabout way to try to prove its, in my opinion, very weak theory. And, you know, and this witness, like, I even had to ask him, like, what is the purpose of this? This witness apparently is trying to prove that, you know, how much love there was for Austin from Diane to Austin, the youngster to whom maybe or maybe not she was going to leave a portion of her estate, without taking into consideration that when a spouse remains alive, there's nothing wrong with that spouse hanging on to the entirety of the estate and then leaving whatever portions to whomever when that spouse dies.
Exactly.
Normal.
It's normal, but maybe the prosecution's saying it's just not so normal. But I'll tell you what's not so normal is when you listen to some of the behavior of Tex McIver after a shooting, it is a little questionable. We'll play it for you in its entirety a little bit later when he spoke with Billy Corey, when he spoke to Jay Grover, people that work with Diane. His behavior was a bit strange. But now I'm going to play you again. This is continuation of Janie Calhoun. She gets into what happened after the shooting. Let's listen in.
In your time with Diane and becoming close friends with her, about how often during a regular week would you say that you saw Diane?
At least 2 or 3 times a week.
And how often would you see Austin there?
He was there at least a couple of times a week, sometimes more than that.
We just showed the jurors a photograph that you described as being taken at the ranch. Tell the jurors, when you say the ranch, what are you talking about?
It was in Putnam County. It was it was a big house. They had a lake out in front, and then there was I say a house behind the house. It was, they called it the saloon, but it had a bedroom and it had the stables for the horses, and that was there.
In your time getting to know both of them, had you actually been out to the ranch yourself?
Yes.
And when you would go out to the ranch, where would you stay?
If my husband was with me, we stayed out in the saloon, as they called it. It had a master suite out there. And if I went with just Diane and Tex, and sometime Danny Carter would go with us, I would sleep in Austin's bedroom in the main house.
All right. You told, we talked about Danny Jo actually staying the night at your condo. And how many nights did she stay there?
2.
Do you remember which night that conversation took place?
With her?
With the details conversation that we talked about with Mr. McIver in relation to when Danny Jo actually stayed at your house?
No, with him, it was just that week. I don't know exactly what.
And would that conversation have been one of the nights that Danny Jo was your guest, was actually still staying at your condo?
Tex was not over at my place during that time at night.
And so the conversation that you told us about in the living room, I think you told the jurors that Danny Jo was there first, and then at some point later Mr. McIver came over.
Yes, and Danny left.
And was she still a guest, an overnight guest at your condo during that conversation?
Yes.
And that would have been in the days immediately following the shooting?
Yes.
We're talking about the Claude Tex McIver here on Law and Crime, trying to understand everything about this case because it's on break this week. So we have an opportunity to fully recap everything. And here's Janie Calhoun, a woman that knew the McIvers very well. And the interesting perspective about Austin, it keeps coming up, Diane's godson. So again, I'm here with Jonna Spilbor. We know as to the ranch, they would tell Austin, this is going to be yours someday. Again, the conversation becomes, Tex McIver got the ranch when Diane died. They didn't make any provision for him to get the ranch before she died. And as I said to you earlier today, if he really wanted Austin to have the ranch because he knew that's what Diane's intentions were, then why did he not just give him the ranch when Diane died?
Because why not wait for he himself to be dead? I mean, it's quite common. Jesse, if you and I are married and there's a godchild, and we could say to that godchild, all of this is going to be yours when we die. Not all of this is going to be yours when one of us dies. All of this is going to be yours when we die. We're leaving you this ranch when the last person is no longer living. Now, you normally don't say that to a child. And oh, by the way, Austin can't do anything with a ranch until Austin is 18 years old. So let's not forget that as well. It's, again, to me, this is taking something that is so natural and common. I'm going to give you everything when I die. And it's like trying to fit a square peg in a round hole to prove motive when motive doesn't need to be proven. But that's the effort by the prosecution here.
A separate part of her testimony, and what we hear a lot of the witnesses testify to, people that knew them well, is after the shooting, Tex wasn't as forthcoming about the details of the shooting. He said Diane died at times. Sometimes he wouldn't even say at first, I shot her. Some people thought they heard there was a car accident or there was an accident in the car. Why would a man who seemingly said this is an accident, didn't have anything to hide, why would he not be forthcoming? Is it some way to explain that away?
Other than, I mean, geez, try to admit that to yourself. If you accidentally, I mean, I had a friend one time that accidentally ran over her own dog. She couldn't talk about that. I mean, if you're responsible for a tragedy, and in this case, the ultimate tragedy, you've killed your spouse, who, if you're going to believe the defense, he had a wonderful relationship with. I don't know. How do you openly talk about that? You killed somebody accidentally, if you believe his story, but you still ended a life. I would choke on those words for the rest of my life. So maybe that's how you explain it.
And we also know he's an attorney, so he knows that everything he says, every detail he gives to anybody can be manipulated, used against him. Even him not saying something is being used against him. So imagine if he said, look, it was an accident, and his story were to change about what actually happened. You look at inconsistency after inconsistency. I mean, look what happened with the nurses at the hospital.
Right.
So many of them said he gave different accounts, and they had their own opinions about him as well. But at least one nurse said, I thought I heard him say he was washing the gun when it went off. Washing the gun?
Washing the gun.
Exactly.
Yeah, who washes the gun?
Everyone knew he was in the car. So if he were to change his story or not be so forthcoming, maybe that was the better move. I mean, he's guilty if he does this. He's guilty if he's not.
You know, you always tell the truth. Just don't always be telling it. And really, the only person that Tex McIver should have been talking to about this incident, two people he should have been talking to: his lawyer, who was going to be representing him, and a therapist. Because, come on, Jesse, he brought about the death of his wife.
Yeah.
And that's no small thing. I mean, that obviously, it's life-changing in many, many ways, but what would that do to a person emotionally, especially if it's an accident? If it were intentional, you'd be like, she's dead. If it's an accident, oh my God, she's dead.
Yeah.
So I just think this is tough. This is tough, and we're not inside his head. And maybe we're going to get there when the defense presents its case, but we're not inside his head yet at all.
Do you think they're going to bring him on the stand or no?
Right now, I don't think they need to. Jury's going to want to hear from him. They are going to want to hear from him. Maybe it's not a bad idea. That maybe he can explain what he was doing when that gun went off. But he probably doesn't have to, and therein lies the rub every time you have a case like this.
Well, we'll have to wait and see, won't we, Jonna? But Tex McIver, as interesting as a case as it is, we're not only covering that. We are also covering another case that begins on Wednesday. That is the plan. It is a case out of Ohio. It is the case of William Knight, a man who went to another man's house and shot him what was seemingly over a dirt bike. That's right. Mr. Knight believed that this dirt bike was stolen from his son-in-law. An altercation ensued, and there was gunplay, and there was a man who died as a result of this. We have a short preview of this case, and we believe it will start Wednesday. We're going to cover it here on Law and Crime. So here's a short preview of that case as well.
For the Streetsboro, Ohio man accused of shooting and killing an unarmed man in a dispute over a stolen dirt bike is set to begin next week. 64-year-old William Knight is charged with murder and assault stemming from an altercation with 24-year-old victim Keith Johnson. The dispute was over a dirt bike reportedly stolen in 2016 from Knight's son-in-law's garage. The victim had the pilfered bike in his possession and was attempting to sell it on Facebook, according to authorities. Knight and his family arranged a meeting with Johnson to discuss the sale of the bike when everything went terribly wrong. Knight alleges the victim tried to run over his daughter Michelle with the dirt bike when confronted with the stolen property.
Ma'am, they tried to kill my daughter.
Okay, hold on. Did you just shoot the man?
I had to. He was trying to.
Okay.
He tried to run into my daughter.
Okay, hold on. Okay.
Johnson's family contends the bike was not stolen and that he purchased it from another seller. Is this a case of self-defense or cold-blooded murder? I'm Rachel Stockman for Law and Crime.
Murder versus self-defense, it's a common theme we cover here on Law and Crime. We've seen a lot of these cases happen before. Majority of the self-defense cases we've actually covered here have ended in a mistrial. So we're going to have to follow and see what happens. And speaking of mistrial, that might be what happens here in the Claude Tex McIver case. I know many of us are split between whether or not Mr. McIver is guilty of murder or not. And as we just played, Janie Calhoun was a friend of the victim as well as a neighbor. I want to play for you right now. This is investigator Terry Jackson, who interviewed Ms. Calhoun. Take a listen to what this statement was from earlier in the case.
And how long did the conversation with Ms. Calhoun last?
It was over an hour.
Over an hour?
Yes.
And can you tell the jurors what was the subject matter that was discussed?
So initially wanted to try to get a little bit of background. She was very good friends, if not the victim's best friend. So kind of wanted to get a little bit victimology. How was the victim, the relationship between the victim and her husband, and then kind of what happened after the incident. How did she come to find out about it, and those type of things.
Okay. And Okay. Can you tell the jurors, in this conversation with Ms. Calhoun, did we talk about with her not only how she found out about the death of Ms. McIver, but what happened in the hours and days after?
Yes.
And specifically, did we talk to her about any conversations she would have had regarding cataloging or organizing Ms. McIver's personal items for sale?
Yes, we did.
And can you tell the jurors what date or day did Janie Calhoun tell us she would have had those conversations regarding cataloging and organizing Ms. McIver's personal items for sale?
She said that it was 2 or 3 days after the death, and that kind of stood out to her.
Did she, did we ask her how she felt about that?
Not sure.
Stop for a second. Yes, sir.
I like that prosecution tactic. You ask a question, you get an answer, doesn't sound good for the defendant, and you wait and you let the jury marinate on it. And what we're talking about there with investigator Terry Jackson is when she interviewed Janie Calhoun found it a bit odd that Tex McIver would be selling things so quickly after Diane died. Jonna, first, good. Do you like the way the tactic is? Clint Rucker, who's the DA, and this has done this countless times, whenever there was a point that he wanted to hit, he would wait. He would wait after the witness gave that statement, wait before he answers his next question, really let the jury think about that. You think it's effective?
No, I think it's annoying. And I also think it's annoying that he's really trying to get this. So he just asked a question that is objectionable. He's talking to an investigator about what the investigator, kind of conversation she had with the prior witness when they were investigating the case. And he stopped for a second, and then the investigator gives an answer, and then he says, did she tell you how that made her feel? Number one, anything that she told that investigator is hearsay. Number two, who cares how it made some other witness feel? That is completely irrelevant. So what I think he's doing, I don't know if he's pausing for effect. I think he's pausing because he knows he's about to ask a question that's going to get objected to.
That's probably true. But stand by, because there's something I want to play for you and for our viewers as well. This is the testimony of Gail Meadows. This witness stood out to me. She was an administrative assistant at Diane's company. What she is about to testify to is when Tex McIver, who she didn't even know that well, showed up to the office right before Diane died. Take a look. This was, I think, the Friday before the shooting. So it's very important, and you can try to hear what the prosecution is making of this, if anything. Let's listen.
Okay, and when was the last day that you saw Diane?
Thursday.
Okay. And on Thursday, when did you see her?
Throughout the day, at different times. Didn't, see on a consistent basis. She came and went.
Do you remember what time she came into work that morning?
I don't really recall. It had to be before 10. Usually around 9:30. I'm not real positive. She didn't sign in. She didn't always come through the front door.
Okay.
She would either, come through the door. In the warehouse. There's a parking there, and she would sometimes park in there and then come through the back.
Okay. So. And if you could, on that day, did you see her husband?
I did.
And who do you know her husband to be?
Tex McIver.
And have you ever met him?
No.
And how do you know of him?
Saw pictures of him, and I did see him in passing when they had maybe a group come in and were leaving for dinner or something like that, but I was never formally introduced to him.
Okay.
And then there's pictures in the hall from the previous pictures of when they won the case with the airport. There was a decision and pictures made with Mr. Corey and Diane and Tex. So I'd seen those photos.
Okay. And you saw him on that Thursday?
Yes.
And around what time of the day did you see him?
It was mid-afternoon, I would say.
I'm going to ask you to ask a question now, and we'll pick up from the question that you asked.
Please explain to the jury what you observed that day.
I observed Tex McIver coming to the office and walking past me. And I was actually kind of surprised with that, because I didn't know that other people could just come into the office. And he went past me and peered into Diane's office, walked past there, and proceeded down to the hall to Billy Corey's office, and then come back and go out.
So, what's your response to that objection?
I mean, I think she can observe how he appears to her. I don't think it requires any type of special knowledge to.
I'll allow it.
Could you continue, Ms. Meadows?
He was red-faced, with a stern look on him, and it's like I've just not seen too many people that look like that. I'm just saying that he was red-faced.
When she objects, you got to stop.
She stands and looks.
Now we have moved on from describing how he looked to characterizing it, her opinion of how he looked. She said, red-faced, stern look, something like, I haven't seen other people look like that. I asked that the witness limit it to how Mr. McIver appeared physically.
Okay. I'm going to ask you to go on to your next question. I'm going to allow that, but we're done with the description.
Okay. I'm going to show you State's Exhibit number 3. And if you could describe exactly how was he red-faced? If you could show me on there.
Well, he didn't look like, I mean, his face wasn't like this, but he was just all red. It was just an all ruddy red face.
Okay, like red, like an apple. If you could describe it, how red?
I wanted to play that witness for you for one real important reason. The prosecution is developing their case, and they have a right to call whoever they want to call. But when you think about who's a relevant witness in the scheme of their case, is this really a relevant witness? Jonna, we know she's testifying to the fact that Tex McIver, in the Friday before the shooting, walked into that office. He was red-faced, or maybe the Thursday before the shooting, red-faced. He had a stern look on his face, didn't say anything to anybody, went in, went out. That's it.
Yeah.
What am I supposed to take from that, from the prosecution? Oh, he looked angry. He looked like somebody that was going to kill his wife in 2 days.
And that's it. I guess that's what the jury is supposed to take away. So they put a person on the stand who has an allegiance to Diane, right? She was Diane's employee, apparently, administrative assistant, who you can tell, maybe because we do so much of this, that this witness wants to do well by the prosecution. You can tell. And if we were able to watch her on cross-examination, she might have a little bit of an attitude with the defense attorney. She wants to do well by the prosecution. That can play either way with the jury. A jury can say, well, obviously we have a biased witness here who's giving us a whole lot of information about nothing. So 3 days before his wife dies, he's red-faced. Does that mean he was angry? Does that mean he was crying? Did that mean he had rosacea? Did that mean he just choked on a chicken bone? Like, what does that mean? It doesn't mean anything. And this is where the judge, we had talked about this before, the judge is giving the prosecution a ton of leeway here. Not fair.
Not fair. And because the standard, don't you have to have every witness for a certain reason?
Yes.
You're building your case. So I still don't know how that ties in to the end game. And when they call so many witnesses, in their case, how do they, in their closing arguments, do they talk about each witness? Do they talk about a flavor of it? Like, are they going to talk about Gail Meadows in the closing? And if so, how does that tie in?
They might say, remember Gail Meadows. She's the one who testified that Tex McIver looked angry just 72 hours before he shot his wife. That's probably how they're going to tie it in. It doesn't make any other sense.
And we know from everybody else, there was nothing abnormal that weekend. There was even Danny Jo Carter, who was the woman in the car. Diane's friend, said nothing abnormal happened before the shooting. Right. So much to talk about. Jonna Spilbor, thank you so much for coming on. I know we have to let you go. It was a pleasure to have you on.
Thanks, Jesse.
All right, everybody. So we talked about Gail Meadows under direct, but really listen under cross-examination. This is brilliant cross-examination work right here about how this defense attorney, Amanda Clark Palmer, really dissects every one of the points made by the state and really just fights against it. This is the cross-examination.